Most founders don't spend much time thinking about shareholder agreements at the start. They might have one put in place, often because someone told them they should, or because it came up in some early legal advice, or as part of setting the company up. But in most cases, it's not something that they would engage with in a meaningful way. They're focused on building the business, getting clients, generating revenue, and making sure things are moving forwards. That's their job. And the agreement just tends to sit in the background until something changes. And that's the point where it suddenly becomes very relevant to have a shareholders agreement. Because a shareholders agreement or a founders agreement is not really about how things work when everything is going well. It's about what happens when it doesn't. It's about change, disagreement, misalignment, and pressure on the business. And those are the situations where the detail starts to matter. At its core, a shareholders agreement is there to regulate the relationship between the owners of the business. It sits alongside the company's articles of association, but it usually goes much further in terms of detail and commercial understanding than the articles would. It deals with things like ownership, control, decision-making, exits, and restrictions. But more importantly, it deals with what happens when the assumptions that were in place at the start no longer hold true. And that's where I see most of the issues arise. Because most founders don't ignore shareholders agreement completely, they just don't engage with the parts that only become relevant later. For example, decision making. At the start of a business, particularly if there are 2 or 3 founders, decisions are usually made quite informally. People talk, people agree, and then they move forward. It's all nice and smooth. There's alignment, there's trust, and things feel straightforward. But as the business grows, decisions become much more significant. They might involve taking on investment, hiring at a senior level, entering into larger contracts, or changing the direction that the business is going in. And at that point, the question becomes less about whether the people actually get on and more about who actually has the authority to make those decisions and what decisions. That's where reserved matters come in. These are decisions that require a certain level of shareholder consent, sometimes unanimous, sometimes a specific majority. And if those provisions aren't thought through properly, they can either create unnecessary friction between the partners or allow decisions to be made without the level of oversight that founders might have expected, people running amok. Another area that's often overlooked is what happens if one of the founders wants to leave. At the start, that doesn't feel like something that needs to be your shares. Are they required to sell them? If so, at what value? And on what terms are they made to sell them? That leads into one of the most important and most commonly misunderstood areas in shareholders agreements, which is leaver provisions. Good leaver, bad leaver. These terms come up regularly, but they're not always properly understood. In simple terms, they are designed to deal with what happens to a shareholder's shares when they leave the business and the circumstances of that departure. A good leaver might be someone who leaves due to ill health or in circumstances agreed between the parties. A bad leaver, on the contrary, might be someone who is dismissed for cause or who breaches their obligations to the company or to the other shareholders. The distinction matters because it often affects the price at which shares are bought back. And this is where things can become contentious if it's not properly understood from the start. If those provisions are not clearly defined, or if they don't actually reflect what the parties intended, disputes can arise and do arise very quickly, particularly if the value of the business has increased. Another area that tends to be overlooked frequently is deadlock. This is particularly relevant in businesses where ownership is split evenly. 50-50 structures are very common. They feel fair, they feel balanced, and at the start, they definitely make sense. But they can create significant issues if the shareholders disagree on something down the line. Because if there's no mechanism to resolve that disagreement, the business can effectively become stuck. No one can force a decision and no one can move forward. That's where deadlock provisions come in. These might include escalation mechanisms, buy-sell provisions, or other structured way to resolve disputes. But again, if those aren't in place, or if they haven't been thought through properly, the business can end up in a very, very difficult position. And so can the shareholders. Drag-along and tag-along rights are another area that founders often don't fully engage with. Drag-along rights allow majority shareholders to require minority shareholders to sell their shares as part of a sale in the company. Tag-along rights is the other way around. That allows minority shareholders to participate in a sale that is initiated by majority shareholders. These provisions are critical in the context of an exit of the business. They affect how a sale can be structured, who can control that process, and whether all shareholders are aligned. But they're often included as standard, without much discussion, without much thought, and then only really looked at when a transaction is actually happening. At that point, it's too late to change them. Restrictions are another key part of shareholders' agreements. These might include non-compete provisions, it might include non-solicitation clauses, and confidentiality obligations. They are designed to protect the business if someone leaves. But again, the detail matters. How long do they last for? What activities are restricted? Are they enforceable? And do they strike the right balance between protecting the business and being reasonable enough to be enforceable? Because if they are too restrictive, a court might not uphold them. If they're too narrow, they may not provide any meaningful protection for the company. And then there's valuation. How are shares valued when they are transferred? Is there a fixed formula? Is it based on fair market value? Is there an independent valuation process? And how is that process triggered? And who can trigger it? This becomes particularly important in situations where shares are being bought back, whether due to a leaver event or otherwise. If there's no clear mechanism, or if it is ambiguous, that in itself can create disputes. And those disputes can be expensive and they can be time consuming to resolve. What sits underneath all of this is a broader point. A shareholders agreement or a founders agreement, they're the same thing, is not just a legal document. It's a reflection of how the business is intended to operate. It's where commercial expectations are translated into legal terms. And if those expectations aren't properly considered at the outset, the agreement won't work in practice. Because when issues arise, people don't fall back on what they thought was agreed, they fall back on what is actually written down in paper. And if that doesn't line up with how the business actually operates, that's when we start to see friction beginning. What I see quite often is agreements that have been put in place early on, sometimes using templates, sometimes without detailed discussion, and then they're just not revisited. The business evolves, ownership changes, new shareholders come in, investment is raised, but the agreement stays the same. And over time, it becomes less and less aligned with the reality of what's actually going on in the business, until something happens that forces people to look at it again. And at that point, you're not building something properly, you're dealing with the consequences of what's already in place, which is always more difficult than just getting it right at the beginning, because changing a shareholders agreement requires agreement. And if the issue you're dealing with involves disagreement, that's a much harder process. This is why it's really important to think about these things early on, not because you expect problems, but because businesses change. People's circumstances change, and what feels straightforward at the start doesn't always stay that way. A well-drafted shareholders agreement doesn't prevent issues from arising, but it does provide a framework for dealing with them when they do arise. It creates clarity, it sets expectations, and it reduces the scope for dispute. Whereas an agreement that hasn't been properly thought through or hasn't kept pace with the business can do quite the opposite. It can create uncertainty, it can create friction, and in some cases it can significantly impact the value of the business, particularly in the context of investment or exit. Because one of the first things that will be looked at in due diligence is the ownership structure and the agreements that sit around it. Are they clear? Are they consistent? Do they allow the transaction to proceed smoothly? Or do they create obstacles along the way? And that's often where issues come to light. Not because they didn't exist before, but because they hadn't actually been tested. And that's really the point. A lot of what sits in a shareholders agreement only becomes relevant when it is actually tested. And if it hasn't been properly considered by the parties, well then that's when it really starts to matter. So the question isn't whether you have a shareholders agreement that's in place, it's whether it actually reflects how your business works and whether it will still work when things change down the line. Because that's ultimately what it's there for.